Hello, everybody. Good to see you all. Oh my gosh. Hello, Auntie M. Hello, Sir Philip. Hello, crazy old Rexy. I love you. Hi, Chataskadam. Oh my gosh. Someone has noticed. They all say hi, Ava. Every one of them, all at the same time. Didn't you hear it? I heard it loud and clear. Hello, Lisette Panette. Hi, Shane. Hold on. I see Shane saying hello to everybody. I gotta find mine. Oh. Okay, Shane. I'll just use Phillips. Hi, Shane. Yes. Ava. Hi, Iris loves tequila. Oh my gosh. She is not having me say hello to anyone until she gets her treats. Because guess what, y'all? As if she wasn't spoiled enough by her secret admirer, she's a not so secret admirer now. And they got her the bacon, egg, and cheese version. Yeah. He just ate something, and so he might be a minute, because the only time he wants to be by me is when he wants food. Hello, Tiana Miller. Yeah, wow is right. Holy cats. Okay, I know. I should make you wait till breakfast, because bacon, egg, and cheese is a breakfast thing, right? She says, treats are anytime. You sound like a little piggy. You're snorting over these. I got to meet Joey Bag of Donuts. Hi, Mason. How you doing, buddy? I'm so happy you're here. So, okay, guys. I got to meet Joey Bag of Donuts, and I feel bad. He's not here right now. He's probably sleeping. I had so much fun. I don't know if he did, because he hadn't been to bed yet. I tried to take him to Murray's on Main, which is like the best restaurant in town here. It's owned by the mayor, Mike Murray, who he's a heck of a guy. He's an amazing person. And so I wanted to take him there, and we get there and all the chairs are up. Oops, I forgot he's closed on Mondays. So we went back and went right across the street from where he had parked. And we just ate at Perkins. And he showed me pictures of all of his paw pets and of his beautiful wife. Oh my God, she's so gorgeous. And, you know, honestly, the thing that I loved the absolute most about hanging out with Joey was the way he talked about his wife and how much he loves her. And it was so beautiful. It really was. Getting to meet him was such a great experience, and I cannot thank you enough, Joey Bag of Donuts, for popping through Toma and letting me know and saying hi. That was so great of you. Mason, I'm going to say hi to you this time. I'm going to say hi again, and you're going to hear it. You're not going to cough this time. I'm going to say, hello, Mason. He really is, you guys. He is so sweet. Oh my gosh. And then he asked me, he said, do you guys have a Tractor Supply store here? And I was, yeah, there's one on the main street. And now he's got his son, I remember. So I was like, when we got done eating and I was taking him back to his truck, I was going to ask him if he wanted me to show him where the Tractor Supply store was. And he asked if I would take him there. And he comes out and I'm like, oh, you're going to spoil your puppies. He's like, no, these are for Ava. Seriously, it was all, it was so hard for me not to cry. He's like, don't cry, you're driving. Crazy old Rexy's got it. Hi, Rocky Lennon. And guess what, you guys? I have a sort of an update on our letter reading Karen. I was so excited when I heard her name. I remembered her name. I'm like, that's gotta be it. So I went back and I checked the stream and it was her. She refuses to come on camera though. But her attorney stands in for her while she sits in the off to the sides. But I can't wait for you guys to see it. We are going to go back to Bellingham, but with a different judge. This is the judge that got me hooked on Bellingham in the first place. This is the one, I thought he was cute. And so I started watching it.
So I'm going to get some documents thrown in here. And Mr. Jackson, I think we're good to go. So if you don't mind coming back up, sir. All right. I'm going to backtrack just for a moment since we can formally go through arraignments. Obviously, we've already established PC. Mr. Lockhart, are you ready to go through arraignment today with Mr. Jackson?
Yes, Your Honor. We can enter the not guilty plea on his behalf.
Okay. So, Mr. Jackson, we've already waived a formal reading of the rights and the charges. So I'm going to enter a not guilty plea on your behalf, Mr. Jackson, as to both of these counts. That plea is now entered. Of course, I've already heard from the city on release conditions. So, Mr. Lockhart, go ahead.
And, Your Honor, as of right now, Mr. Jackson is not currently working, but he is a stay-at-home dad. He has been in Whatcom County his entire life, and that, as of right now, he does not have any money to be able to post any amount of bail. He does receive treatment through the methadone clinic, so there are, treatment services that he would need access to if held in custody that I don't believe he would be able to get to. But as of right now, we are just asking for a PR release. He does not have any prior DV history, any convictions or anything. So we're just asking for that PR release based on not only the income, but also the lack of DV history.
Okay, thank you. I need just a moment here since Mr. Jackson was just added to the calendar. I was not able to look at his history prior to this, so I'm going to look at the history right now.
And, Your Honor, we can call the matter of Aaron Jackson.
All right, Aaron Jackson. This would be cause number... Actually, I don't see Mr. Jackson on the list. Is this an add-on?
It is an add-on, Your Honor. The citation just hasn't come through yet on this one, and it's not in my queue, so
okay, so
this is going to have to be a first appearance here today.
Okay. All right, well, Mr. Jackson, good morning, sir. How are you?
Not good.
All right, sorry to hear that, Mr. Jackson. We'll see what we've got going on here today. Pretty sure I did review the PC on this one, Counsel. Is this the alleged DV?
That is correct, Your Honor.
Okay, I did read it then. All right, well, any comments on probable cause, Mr. Lockhart?
No, Your Honor.
All right, court will find probable cause for, if memory serves, as 2 counts. Is it A4 and malicious mischief?
That is correct, Your Honor.
All right, court finds PC established on both charges. And with that, Counsel, I guess we can't go through arraignment, so I'll just ask you, have you reviewed the charges and the rights with Mr. Jackson?
We did, yes, Your Honor.
All right, and asking to waive a formal reading this morning?
We would, yes, Your Honor.
All right, Mr. Jackson, any questions at all, sir, about your rights or the charges?
No, Your Honor.
All right, I will waive the formal reading. Because we don't have the ticket formally filed, we cannot enter pleas either way for you today, sir. So I'll just go ahead and hear from the city attorney on release. Go ahead, Mr. Kilfoyle.
Your Honor, at this time, the city is going to be asking for $1,000 cash or court-approved performance bond per charge for a total of $2,000. Your Honor, the defendant has prior history of at least 3 prior assault in the 4th degrees. I'd note they're not domestic violence. However, that's 3 prior assault in the 4th degrees. The city was going to be asking for a domestic violence no contact order to be put into place. I don't have a physical copy of the form, but I was curious if the court could potentially, since O Court doesn't have any documents yet, if we could print out a blank from another case and then I could fill out the information on a blank for another form. All the information should be on it.
I suppose that's
if that's possible for the court.
I guess the only problem is I think it would have the other cases heading on it.
I don't know if we could just do whiteout on that because it'd be a physical copy.
Would you rather do that than just the paper copy that we have?
If the court has a paper copy, I'd love to use it. I'm out of the paper copy up here.
Contact orders. I think we might just need to do that.
Okay.
We'll get
And then,
one.
Your Honor, I think that while I would note for the record that in the PC statement there's no allegations of
Sorry about that. Thank you.
Your Honor, while there is no allegations of alcohol or drugs in the PC statement or the official report, I would note for the record that drugs are alleged in both the LAP form as well as in the CAD log itself. However, I just wanted to note that for the court's information. Should there be any further issues on this case, I think we would be asking for pretrial monitoring. I don't know that there's quite enough here without anything in the narrative or the PC statement at this time to get to pretrial monitoring.
No drugs.
I think it's important to note that in conjunction with the defendant's history. If the court was willing to take that information and add pretrial monitoring, the city would greatly appreciate it. I just understand that the court's not willing to, since there's nothing directly in the PC statement or directly in the
You're
report.
crazy. That's crazy.
So at this time, Your Honor, I'm just going to go. That would be the city's request in total. I'm going to work on this paperwork here.
Before you do that, my clerk just let me know that it popped into sectors, so I think we can actually go through arraignment and get it added to the calendar.
Perfect.
If you don't mind sitting tight for 1 second.
That would be great, Your Honor.
Perfect. All right, Mr. Jackson, we're going to be just a moment because my clerk does need a minute to get this formally added to the calendar. So just hang tight.
Okay.
I'll be back with you in just a moment.
Okay.
Mr. Jackson's winding up like a top.
All right.
Okay. So here's where I'm at. No DV history, as counsel noted. I don't see any. Looks like 3 prior assaults, if I'm reading that correct. One was from 2021. One was quite old. It was 2006. I just lost track of the third one, so I've got to find that real quick.
I don't even know of any assault charges, Your Honor.
All right, well, I'm not going to get into all of the details of them, but just so you're aware, Mr. Jackson, I see conviction, assault 4th degree, Bellingham Municipal Court, 22721. That does show on your history. I show the old one was from, actually, no, there's also one, 22621, out of Whatcom County Superior Court. And then there is one much older, that is the one from 2006 out of Whatcom County Superior Court. So 3 prior assault convictions. Based on that, the court does find there is a risk of a violent offense being committed. We have 3 prior assaults, although none are domestic violence. Warrant history isn't terrible, but there's about 10 or 12 cases with warrant history. So the court does make a finding there's some risk of non-appearance. I will, however, take into account Mr. Jackson's financial situation. city's request is probably pretty reasonable, frankly, but given Mr. Jackson's situation, I'm just going to set it at $250 cash performance bail. At this point, I'm going to order Mr. Jackson not to possess or consume, but I think council's right. I don't think I really have enough to go all the way to pretrial supervision, so I'm not.
Understood, Your Honor.
So that'll be the order here today. It'll be $250 cash performance bail based on the 3 prior assault convictions, but taking into account Mr. Jackson's financial situation, I think that's reasonable.
And I'm sorry for interrupting, Your Honor. Is that 250 per charge, or is that 250 total?
I'm just going to do it total.
So
I
125
recognize
each.
that realistically the city's request was probably reasonable, but just trying to take that all into account here. So, Mr. Jackson, if that bail is posted, there's going to be a number of conditions here. Appear timely for your scheduled court hearings.
I don't have any money.
Have no new criminal
I
law
don't wanna-
violations. Yeah, and Mr.
Just sit in
Jackson,
jail then, I guess.
I did take into account your financial situation.
Yeah,
when
I
setting
appreciate. I
the-
don't have any money. I'll just sit in jail.
All right. Well, I'm going to finish going through the conditions, but looks like Mr. Jackson does not wish to stay, so we can enter the no contact order nevertheless. So I'll be just a minute filling out the order. I'm going to find Mr. Jackson eligible for the public defender. All right. And it looks like you've got everything filled out there, Mr. Kilfoyle, on the no contact order. Is that good to go?
I believe it is, Your Honor.
Perfect. Okay. All right, and the no firearms box is checked, and that is because of prior felony convictions, so I will leave that checked. Do that. Okay. All right, I'm going to sign off on this order. For the record, of course, Mr. Jackson has left the courtroom, but the court does have authority to enter the pretrial no contact order even without him present, and I'm going to do so. July 11th, you said? Okay. All right, I got to add a couple of dates here. I mean, we have gone through arraignment, so at this point, Mr. Lockhart, do you just want to do the standard 2 weeks for pretrial?
We would, Your Honor.
Okay. So that'll be June 3rd, 8:30, and then my clerk says July 11th, 1:30 would be the
You're
pretrial.
fucking stupid. You fucking bitch ass fucking Walker County. You suck dick. $250 for fucking malicious third. You guys are stupid. Fucking give me my medicine. You guys don't know what the fuck you're doing. Obviously.
All right, Mr. Lockhart, anything else ready to go?
Your Honor, we can call the matter of Anthony Poff.
All right, Anthony Poff, cause number 4A0173831 on for
Mr.
an
Jackson, you're
arraignment.
good to go.
You would think that that would be enough for him, but over the course of the next 2 hearings, you'll hear him in and out, slightly less loudly, but there.
All right, is Mr. Poff in the courtroom? There he is. Morning, Mr. Poff.
Good morning.
All right, this is on for arraignment. I did review probable cause. Mr. Lockhart, any comments on PC?
No, Your Honor, I reviewed that earlier.
All right, court does find probable cause is established on both charges. With that, are you ready on arraignment, counsel?
Yes, Your Honor. At this time, we did go over rights. He did sign off on those rights. We waive a formal reading of those and enter a not guilty plea on his behalf.
Thank you. Mr. Poff, any questions at all about your rights to the charges, sir?
No.
All right, I'll waive the formal reading. Not guilty pleas are entered on your behalf as to both. And with that, Mr. Kilfoyle, go ahead on release conditions.
Your Honor, at this time, the city would be asking for $1,000 cash report per performance bond as well as pre-trial monitoring with UAs. The reason for this, Your Honor, is while the defendant might not have any history in the state of Washington, we haven't had an opportunity to run an NCIC yet. I would also note that the alleged facts here allege that law enforcement had actually contacted Mr. Poff on an unrelated matter just prior to this incident. They noted his intoxication at that point, and then the alleged driving through the parking lot, destroying the bushes and causing that damage, and then returning to his home, at which point law enforcement had to contact him there. This was also a BAC refusal as well, so you have an accident, a refusal, and high intoxication that was noted by the officers. I know that bail's a little bit high, but I think that some bail and pretrial monitoring are warranted given these facts.
Thank you, Mr. Kilfoyle. Mr. Lockhart, go ahead.
And, Your Honor, as of right now, Mr. Pop, although he's only been in Whatcom County 6 months, he has lived in Washington the majority of his life. He does have family all over Washington. He is currently working as an electrical engineer, and that, there are no prior DUIs in any sort, and any kind of last criminal conviction was in 2003, so quite a significant amount of time. I don't believe that there's any real danger to the community aside from the nature of the charge, I guess, but officers' evaluations are not any kind of PAC numbers, so at this point we're just asking for a PR release. The court feels it's necessary for, pretrial monitoring as perhaps a least restrictive means. I don't think there'd be that much of an argument in lieu of bail at this time.
All right. Well, Mr. Poff, I can see that there's no prior DUI history in the state of Washington. Counsel noted they haven't run an out-of-state history, but obviously that means that just isn't before the court right now. So I am going to release you on your personal recognizance, Mr. Poff. I'll note any objection from the city, but with no prior DUI history, I think that a PR is appropriate. I am going to find, though, that the least restrictive alternative here would be pretrial supervision. The reason being, we have a refusal case. We do have an alleged accident. Those are two, to me, aggravating factors here that would make pretrial supervision appropriate, even with a lack of DUI history. So, Mr. Poff, you are going to get out of jail today, but there's going to be some fairly strict conditions on pretrial supervision. So, once you're released from custody, you'll have to report to the Whatcom County District Court Probation Department. Their office is located on the 4th floor of the county courthouse. That is the building that's directly next to the jail. Do you know which building I'm talking about, sir?
I don't, but I shouldn't have a problem finding it.
Okay, you'll get the order, the address is on there, but I guess the easiest way for me to describe it is when you walk out the front doors of the jail, Mr. Poff, you're going to be looking right at the building I'm asking you to go to. So
okay.
Just head on over there, check in with them on the 4th floor. They are going to monitor a number of conditions. Of course, appear timely for all of your scheduled court hearings, have no new criminal law violations while the case is pending, do not drive without a valid license and proof of insurance, have no drug or alcohol-related infractions, do not use or possess alcohol, non-prescribed drugs, or marijuana, do not enter any establishment whose primary business is the selling or serving of alcoholic beverages or marijuana, and you would be subject to random urinalysis at probation's discretion. Do you have any questions at all, Mr. Poff, about any of those conditions?
I do not.
All right. Mr. Poff, would you like to screen for a public defender, or do you intend to hire counsel, sir?
I would like to screen, I guess.
Okay. Are you, I guess I'm answering my own question. You are currently employed, is what counsel said?
Yes.
All right. Do you receive any public benefits like food stamps or anything like that?
I do not.
No? Okay. So you are going to have to apply online, but I'll give you the link, the website that you need to go to apply. Probably best to do that sooner than later, Mr. Pop, so that if you are eligible, we'll get you an attorney on board. But we just need to review some additional information that I can't do on the record here today. So we'll go ahead and do that, and then we just need to find a pretrial. Where are we going for that? July 15th. Okay. July 15th at 1:30 in the afternoon would be your pretrial hearing, Mr. Poff.
Okay.
All right. I think that covers everything we needed to do this morning. Do you have any questions, Mr. Poff, at this point?
I don't.
All right. Well, we'll see you on July 15th at 1:30. Please make sure to check in with probation upon your release. And other than that, just make sure to apply for the public defender if that's the route you choose to go. Otherwise, you always have the right to hire an attorney if that's what you wish to do.
Okay.
All right. Thank you, Mr. Poff.
Thank you.
All right. Mr. Lockhart, go ahead. All right. Salvador Cortez, 4 cases, 1A0429437. Hello, Mr. Cortez.
Hi, good morning, Your Honor.
Good morning. 3801-66680, 3801-29292, and 3801-33091. 3 of them look to be on for pretrial. We do have one arraignment case that's much older. I'm not sure how that snuck by us before, but we'll have to review that. So I guess let's do the arraignment case first. PC was established on that, looks like, way back in 2021. And then the warrant has simply been outstanding for 3 years. So, Mr. Lockhart, are you ready on arraignment on that one?
Yes, Your Honor. We did go over rights. We waive a formal reading of those rights, and we just asked to enter a not guilty plea on his behalf.
All right, Mr. Cortez, just on that one case, do you have any questions about your rights or the charges, sir?
No, Your Honor.
All right, I'll waive the formal reading. A not guilty plea is entered on your behalf on the 1A cause number. And with that, I guess, Mr. Kilfoyle, if you just want to address the conditions on all 4 of them.
Yeah, I can just do that, Your Honor. I can tell the court right now the defendant still has 4 active warrants. It looks like they're out of Ferndale municipal driving cases is what it looks like, as well as this looks like a Burlington or Blaine municipal.
Yeah, it looks like Blaine.
So at this time, Your Honor, the city is going to be asking for $1,000 cash or court-approved performance bond. I would note that these cases are all older. The most recent is from January 18th of 2023, so already over a year old, but we have an assault in the 4th degree, domestic violence, malicious mischief in the 3rd degree, domestic violence, another A4 domestic violence, and interfering with reporting domestic violence. So I think $1,000 cash court-approved performance bond per case is appropriate at this time. And I would just ask for any of the prior imposed conditions be reimposed at this time. I do note that on at least one of these matters, it does look like a GPS order had been previously ordered on the 292, as well as the 680. It looks like it might be on the 091 as well. So that's 3 out of the 4. The arraignment that we just did is a driving license suspended. I don't think we need to add that GPS order to that case.
Okay.
However, I think the $1,000 cash court-approved performance bond for that matter, considering the number of driving-related offenses the defendant has both pending as well as convictions for, I think it is appropriate.
Okay. All right, Mr. Lockhart, go ahead.
And Your Honor, Mr. Cortez does have a job lined up when he is able to get out. Unfortunately, there was a number of FTAs just due to him having to take care of children. Unfortunately, the mother is no longer in the picture. It looks like a number of these, well, at least the older matter for arraignment was definitely one of them that was set over from, looks like COVID, and looks like my office was actually appointed because of that. Unfortunately, we withdrew after the year, just without any, any indication of contact or anything. As for the remaining matters, we would just be asking for effectively nominal amount of bail. I don't believe he's in a position to be able to post the $2,000 cash for the Superior Courts, and I can definitely let our office know that we can see if we can get appointed on the Blaine as well.
Okay. All right. Well, a couple of things to consider. I'm looking at the docket from the previous cases. It looks like the 3 that were in pretrial status, so not the driving charge, but the 3 other cases, 2 of them were set at $500, 1 was set at $250. So what we've had since then is obviously a failure to appear. It looks like, I'm going to double check the history, but I think I saw a new no contact order violation conviction, unless I misread that.
That is correct, Your Honor. That looks like that's out of Everett, or not Everett, excuse me, but I think that's out of Snohomish County, the district court down there, Southern District, so that would be Linwood area. And then there's a no charges filed criminal case out of the Evergreen District Court, which most likely means that's going to be a felony referral.
I think based on that, I mean, we have 3 of these cases are domestic violence offenses alleged. We have a subsequent domestic violence conviction for protection order violation. All of these were in warrant status. I show those active warrants out of Ferndale, Blaine. The Superior Court case was in warrant status. The court does find that Mr. Cortez has violated the conditions of pretrial release. I understand he's held on the high bail out of Superior Court, but I feel at this point, I mean, an increase is really the only appropriate way to go because there's been all these violations. So the 2 cases that were set at $500, I will set at $1,000. The 1 case that was set at $250, I'll set at $500. So I'm going to find out the cause number real quick. I believe the 091 was the $250. Yeah, it was. So 091, I'm going to set at $500, and then the 292 and 680 will be $1,000 as the city requested. On the driving charge, however, that one, I understand Mr. Cortez has a lot of some driving history, but it is, correct me if I'm wrong, it's just it's a D2. Okay. Well, I'll set it at $250 on the D2. So
Thank you, Your Honor.
that'll be the
Thank you,
order.
Your Honor.
And then all previously imposed conditions remain in place. Let me just confirm with my clerk. We don't need a new GPS order, right? Because we still have a good one. All right, so Mr. Cortez, if the bail is posted here and in Superior Court, you'd have to report to Whatcom County District Court probation immediately upon your release. Continue with the pretrial supervision that was previously ordered. The active GPS bracelet would be attached prior to any release. That is through FDS. That is at no cost to you since it is on a pretrial status at this point. I am going to find you eligible for counsel on all of these. We will get you an attorney on board. Be
I had a
one more
question,
second
Your
with the order, Mr. Cortez, and then we'll review it all together here. Mr. Kilfoyle, you said that all three of the old case numbers had the active GPS?
Yes, Your Honor. That's a note I have back from January 20th of 2023. There was an in-custody arraignment where the defendant had pled guilty.
Interesting, because yeah, now that I'm looking at it, usually it's listed in the docket here, and I don't see anything.
My apologies, Your Honor. It looks like there's
Was
a
it
slash
requested
next to
and
the
not-
GPS, so it was there was no GPS ordered at that time.
Okay, I am finding that that is, at this point, appropriate, so, Mr. Kilfoyle, if you don't mind just throwing up that order.
Absolutely.
All right, Mr. Cortez, we're going to set a couple of court dates here. One will be in custody, one will be out. The in custody date will be 2 weeks from today, which is June 3rd at 8:30 in the morning. And the out of custody, July 11th, you said for DV? All right, July 11th at 1:30 in the afternoon. All right, the conditions, just to be clear, I'm just reiterating the conditions that were already ordered. Appear timely for any scheduled court hearings, have no new criminal law violations. As to the driving charge, do not drive without a valid license and proof of insurance. Abide by all active no contact or anti-harassment orders, and abide by the GPS order. The GPS order basically prohibits you from going within 1,000 feet of a particular address. It'll be on the order, but I don't want to read the address into the record here. And FDS, that's the company that runs the bracelet program. Again, that's at no cost to you, Mr. Cortez, but they would attach the bracelet prior to any release from custody, and it just ensures you don't go within 1,000 feet of that address. Do you have any questions, Mr. Cortez, about how that works?
No, I did have one question at the end though.
Sure. All right. I think actually we're there. Go ahead, Mr. Cortez. What's your question?
So, I don't know if I just heard that there was a pending felony warrant. I don't know what that was for.
I think it maybe was served. You had, I'm looking at the jail roster right now, Mr. Cortez. It says
Right.
burglary second degree, Whatcom County
right.
Superior Court, $20,000
Is it-
bond or $2,000 cash.
Yeah, I heard evergreen. I don't know what that means.
I'm not sure. I don't see anything out of, oh, Evergreen, was that the one out of,
Yeah, it's the Snohomish County.
that's the Snohomish County.
Yeah.
So
Yeah.
it's not a warrant out of that jurisdiction. That's the conviction, or rather it says no charges filed. So that's the one that you said is pending, Mr. Kilfoyle.
Correct, Your Honor. If you go over just one line, it says dismissal reason is filed directly to Superior Court. So
Oh, yeah.
that's their way of saying that it was a felony referral that is in the process of being moved up. So there will be charges coming. I don't know when that will be, but that's usually their procedure.
All right, so unfortunately,
what
Mr.
is-
Cortez, that's about all the information we have on that one, but it looks like there might be charges filed in Snohomish County Superior Court.
Can I have any information on what those are? Or?
We don't have anything more than that. Our docket just says filed direct, no charges filed in district court down there, but it says, there's a docket note that says filed directly into Superior Court.
And sorry to interrupt, Your Honor. I would just clarify for the defendant's sake that he's not being held on that. The felony he is being held on is that burglary in the second degree out of Whatcom Superior Court.
Okay, because I'm just confused. I just got transferred from Snohomish County, so I don't know what happened. Like, I don't know why I'm being charged with a felony, but okay.
Okay. Well, we don't have any more information on that right now. What I have done, sir, is found you eligible for counsel. So if there's any questions that come up, your attorney would be the best person to ask about that. They'll probably be able to get more
Okay.
information
Thank you.
than I will. So, all right, I'm going to go ahead then and sign off on the active GPS order. Thank you for filling that out, Mr. Kilfoyle. And If I could just get signatures via Zoom on that, Mr. Lockhart.
Yep.
All right, Mr. Cortez, I think that does cover it all. Do you have any other questions, sir?
No, Your Honor. Thank you.
All right, thanks, Mr. Cortez. You're good to go.
Ooh, the judge did not like that. Doubled his bond amounts. And then he gets the news that not only are his bond amounts doubled, but now he has charges coming that were filed directly to Superior Court for felonies. And I loved his response. Oh, I just got out of such and such county. Okay, so you've been criming all over the place. And the next one is where our lovely Karen of the Ball comes in.
Your Honor, what was that out of custody date?
July 11th.
Thank you.
Let me make sure I actually put that on the order before I move on here. I did. Okay.
Melanie Copeland. I was all ready to tell you happy birthday on the 23rd, and then you weren't able to make it that night or the next night, and I've missed you. But I hope you had a really happy birthday, and I'm so happy you're here now. I love you.
All right, Mr. Lackey, are you ready to go?
Yes, Your Honor.
All right. Matters of Jennifer Block.
That's her, Jennifer Black.
We have 3 cases, 4A0371901, 4A0302637, and 8Z05862236.
Ms. Block's present in the courtroom, Your Honor. She can hear you, but she wants to stay seated.
Okay, that's just fine. So we're on for readiness here today. Current trial date, let me just double check it here, set for June 4th at 9 a.m. Just so both the parties are fully aware, we set this knowing that that was the week of judicial conference and the court was going to do everything it could to secure a judge pro tem if that was even acceptable to the parties. The court has not been successful. We have reached out to all of our judge pro tems. We do not have someone who is available that day. So realistically, I don't think that day is going to be possible for the jury trial. With that, we can move forward from here, but Mr. Lackey, would defense like to be heard?
Yeah, I recall that was the situation when that date was set. It's my understanding that there's also an issue with witness availability for the city. I guess I just would be curious, next available dates, 11th or 18th?
Next available for the court, obviously, we'll have to hear from Mr. Kilfoyle for the city, but the court would be the 18th. We have set aside specifically, I know we have the holiday on the 19th, but we're going to do a jury trial that day regardless. So if it goes into 2 days, it would be a Tuesday, Thursday trial. But that's the next available date. Judge Lev is out through the 11th of June. She's not back until the 12th, so the 18th would be the next available date.
That would be our request then.
All right, Mr. Kilfoyle, would the city like to be heard?
And Your Honor, I'm going to need a second. I can tell the court on the one case, the driving license suspended in the 3rd degree ending in 236. That's the older case. That would be the first in time. That case, that's the one that has the officer unavailability. And my understanding is that officer is going to be unavailable in the end of June and the beginning of July. So at this point, I don't believe the 18th would work.
So Ms. Block's not held on that charge.
So we
She's
have
PR'd, and I am much more concerned about the DUI, reckless endangerment. So that's the one that I think would be going on the 18th.
I'll need just a second to confirm officer availability for the 18th. If the court will give me just a second.
Sure.
Your Honor, I have an officer who's out from June 17th through the 21st, so the 18th wouldn't work. Those dates. And the other date was the 11th. Was that
the 11th is not, Judge Lev's not here on the 11th, so it'd have to be the 25th.
I don't think that's going to be able to work with my officer's availability, unfortunately.
I thought you said he was back the 21st.
Technically, the vacation ends, but if he is off shift, he's going to be out on his days off until that next week. So it wouldn't realistically be until the beginning of July.
Okay, well, Ms. Block's held in custody on this. I'm hesitant to push it out that far. Mr. Lackey, do you have any suggestions or any further information you want to be heard on?
Just that Ms. Block wants, I guess, a trial. She's not willing to waive. She's been in custody this entire time. We're asking for the soonest date possible. If the 18th doesn't work, it doesn't sound like the city's entirely certain about that officer's availability. I'd ask to set it at that date and see where we're at.
Your Honor, I can tell the court that both my officers are available on July 2nd, which is just 1 week later than the 25th. I know with certainty that both my officers would be available on that date.
I'm not available that week.
Okay. I'm just looking here. We have so few options. So 4th and 11th just aren't going to work. Judge Lev just isn't here. Mr. Lackey, let me even ask this just to clarify. If there was a date available when Judge Lev wasn't here, is your client agreeable to a Judge Pro Tem or myself hearing the case?
I would say no.
No? Okay. All right. That does limit us, which is fine. Ms. Block does have the right to have the presiding judge hear it. But that means the 11th won't work. I will be here on the 11th, but we'll skip that. So, okay.
She could also be released with conditions.
Okay. So here's what I think I might want to do. Let's, Mr. Kilfoso, I know technically your officer's on vacation the 18th through 21st, whatever that date was. The 25th is a Tuesday, so you're saying they'll be off that whole week?
That's my understanding as to how their vacation schedule works, Your Honor. They butt it up against their time off to extend because that would be their off week due to how their schedules are. That's my understanding, but I can confirm that. If we want to set the date for the 25th, I can reach out to the officer and double check and see if they would actually be back at that point, and then at the next readiness, I can confirm that.
I think for today's purposes, let's set it at that date because Ms. Block is in custody. I want to get this case heard. Obviously, we have to deal with everyone's schedules, but what I will say is if we're pushing this thing out into, mid to late July, the court might consider another bail reduction, but we're not there yet. But right now, we need to get this thing heard. So for today's purposes, the court will make a finding that due to the court's unavailability, the presiding judge is at judicial conference on June 4th and is on vacation on June 11th, a pre-scheduled vacation, that we don't have judicial availability. There is good cause to extend the time for trial. And the next available date where it looks like it will work for everyone is 6/25. So that is the date that we're going to enter today. If there are issues with that, of course, we will address them. But today, 6/25, that would put status hearing the Friday before, which will be 6/21 at 8:30. And then readiness would be 6/10. At 8:30 in the morning.
And Your Honor, I can tell the court right now, I'm going through, I just want to make a record of this. So if this, for whatever reason, does not go on the 25th, my officers and myself are available on July 2nd, which is just that week later. I know that's butting up against the 4th of July holiday, but I don't anticipate this would take more than the 2 days of July 2nd and July 3rd at the most. And then if we have to go beyond that, though, I've got officer unavailability through most of July. I have the two officers, one has time off in June, one has time off in July, and there's that small 2-week window where 1 week is for sure we're good to go. The other one is the one that I'm going to have to find out more information on. So I just wanted to put that on the record for the court.
Okay. All right, well, I'll go ahead and Mr. Lackey, did you want to be heard any further on those dates today?
I mean, I'm fine with those dates. We just, as you mentioned, we need to get this thing heard. She is in custody. So that's our request. See if we can get this done on the 25th.
All right, those will be the dates then. I did upload a new pretrial conference form just because it has all 3 of those dates in there. If council would please sign off on that, and then I think that'll take care of it for today's purposes.
I will sign off on that, Your Honor.
Thank you. And I am formally then, I have to strike the jury trial on June 4th because of that unavailability of our presiding judge. So I'm going to do that here today as well. Who do you have ready next, Mr. Lockhart?
I can imagine Karen sitting in the gallery area there with her arms crossed like a petulant child, thinking she's getting one over with her attitude, because she could have her case heard earlier if she would allow it to be heard by a different judge. But no, she will only allow it to be heard by that one judge that's not available. And she doesn't want it as early as it could be, because it could be earlier. She's the one holding it up, but then she wants to whine and complain that she's being held in custody. Sorry, Karen.
Your Honor, we can call the matter of Brianna Baker.
All right. Ms. Brianna Baker, cause number 4A0271937. Ms. Baker, good morning, ma'am.
Good morning.
All right, on for pretrial today. What is defense request?
And Your Honor, we're asking for a motion to continue with the speedy waiver. This matter is unfortunately kind of taken into consideration with the Superior Court side of things. She originally had a jury trial scheduled for this morning as well. It looks like they might have stricken that, but it sounds like we just need an update on what's going on with the Superior Court matter. So we are asking to set this out the 2 weeks, but we'll be noting her back up to most likely resolve once we figure out what's going on with Superior Court.
Okay. All right. Well, I'm sorry to hear about that, Ms. Baker, on your Superior Court matter. But
I have a question. So, I thought I was going to Superior. They strict it.
So right now, I don't know, Ms. Baker. You might be transported over there. I just honestly, I can't tell you what's going on right now at this point.
Okay.
okay. So, Ms. Baker, today the date requested is June 3rd, 8:30 with that speedy waiver for our case. Do you have any questions about that, ma'am?
I thought I was supposed to be this Wednesday.
And we can get you noted up for this Wednesday if we have a resolution. Okay.
Okay, perfect.
Okay. All right. Any objection, Mr. Kilfoyle?
No, Your Honor, I'll sign off.
All right. Signing off as well. All right, Ms. Baker. Thank you so much, ma'am. You're good to go.
Thank you.
All right. Anything else ready, counsel?
Your Honor, we can call the matter of Andronica McDow.
All right, Andronica McDow, 2 cases, 4A0475853, that's on for arraignment, and 1A0171706. Ms. McDowell, good morning, ma'am.
Good morning, Your Honor.
All right, so just taking a look here. One of these, I guess we better start with the arraignments. Mr. Lockhart, I did review probable cause on that new case. Any comments on PC?
No, Your Honor, I did review that earlier.
All right, court does find probable cause is established on, I believe it was 2 counts. Let me just double check that. Yeah, D3 and no ignition interlock. So PC is established there. Are you ready on arraignment, Mr. Lockhart, on that case?
Yes, Your Honor. At this time, we'd waive a formal reading of rights, waive a formal reading of the probable cause, and enter a not guilty plea on her behalf on that particular charge.
All right, thank you. Ms. McDowell, any questions about your constitutional rights or the charges just on that new case?
No.
All right, I will waive the formal reading. Not guilty pleas are entered on your behalf on both charges there. And Mr. Kilfoyle, go ahead if you want to address release conditions just on both cases at this point.
Thank you, Your Honor. At this point, I'm going to start off with the new arraignment matter. The city's going to be asking for $250 cash court-approved performance bond. charges of no ignition airlock device and driving license suspended in the 3rd degree. The defendant has a recent conviction for DUI. The city is also, on the other case, on the 706, the assault in the 4th degree matter, the city is asking for $500 cash or court-approved performance bond and asking for, I don't know if probation has a file for this matter here today.
I'm sorry, who is it?
McDowell.
Oh, yes, I'm sorry.
We're going to need to have the probation matter heard this morning as well. Initially, this had been on for bench warrant quash a few times, and we were going to just ask for, because I think initially this had been an FTA at a probation hearing back in, I think all the way back in July of 2022.
All right, so a pretrial violation.
Pretrial violation. So at this point, Your Honor, I think that a $500 cash court-approved performance bond and maintain the other pretrial release conditions that had previously been imposed would be appropriate given the extensive FTA and the fact that this is a 2021 case. Thank you, Your Honor.
So one thing to clarify for the record, I think, Mr. Kilfoyle, you said a recent DUI. I'm showing the DUI is 2013, so pretty old.
My apologies, Your Honor.
Very.
Just wanted to make sure that was clear. Other than that, Ms. Souza, did probation want to be heard this morning at all?
Your Honor, I'll defer to the city on this. We are recommending a cash performance bail, but defer to the prosecutor on the amount.
Okay. All right. So, Mr. Lockhart, obviously a couple of things to address. Release conditions on both, and I guess formally, we do still have those 2 outstanding violations of pretrial alleged, stated July 27th of 2022. So, would you be able to admit or deny those today?
And Your Honor, we just asked to deny those at this time.
Okay. Would you like to be heard on release conditions?
And Your Honor, currently Ms. McDow, is taking care of 2 children, but she's been in Washington County her whole life. She is going to be re-engaging with Lifeline Actions for treatment, and that she's currently just waiting on a job for a lot of the funding issues, which is why this matter was going to kind of reset a number of times. She did hire private counsel in the past. Unfortunately, with Mr. McKee no longer practicing law, that kind of went by the wayside. It sounds like she did go through an application for public defender, and maybe she just needs to show benefits. But I think the big thing was just waiting on the warrant. So I do believe that she would be eligible for public defender based on her current financial situation. So we would ask to be appointed. We'd ask for her to be, released on her personal recognizance on these matters. It sounds like she is in good communication with the court, so I don't think that's the issue. I think it's mostly just having to reset these.
Okay. All right. Well, on the new charges, the D3 and the no ignition interlock device, I'm going to PR Miss McDowell. She has no other driving-related history other than an 11-year-old DUI. So really, I think a PR is entirely appropriate on those charges. As for the assault 4th degree, city's request was $500. The warrant was issued at $250 cash performance. I'm just going to leave the warrant as is. I think $250 is appropriate. That's what the warrant was issued at. It was booked and returned, and that seems entirely reasonable to me. The PR is not appropriate here. Ms. McDowell has been on warrant status for almost 2 years. I simply cannot PR her at this point. But Judge Lev issued it at $250. That's what I'm going to set it as, $250. So that's what it's going to be ordered here. You are still on pretrial supervision, Ms. McDowell, so if you are released from custody, you have to report immediately to the Whatcom County District Court Probation Department. And just to be crystal clear for the record, the $250 today is not really taking into account the violations alleged. So, of course, the city can address conditions there at the review hearing if there is a request for increased bail. Today it's been a denial. I'm just entering the $250, Mr. Kilfoyle, based on basically where the warrant was issued at. So we will address the additional request at the review hearing once we're able to go through with that.
Understood, Your Honor. I just asked the court to note the city's objection for the record.
Will do. It is noted for the record. So, all right. I'm going to go through the order here, ma'am. Give me just a minute here. Mr. Lockhart, I guess my question is, would your client want a relatively low bail amount imposed on the driving charges if she's not able to post the $250?
And Ms. McDowell, this question's more for you. If you're not able to post the $250 cash, did you want to earn some credit on the new matters, or are you able to post the $250 in cash?
I have nothing. I spent the last 5 years trying to get my children's father clean and sober, and thank God I have, and he has, but it's been impossible for me to attend any treatment classes after losing the telehealth option because I am not a licensed driver and I have 2 children in my care, and he refuses to help me when I do need help with them, even for court, to the point of like walking out of the house just before a court date. And yeah, it's been really difficult being the only person responsible for them and being able to meet everybody's requests.
Your Honor, we just
because I just don't have childcare, and I don't have money, and I don't have help.
Okay, well, I'll impose the $25 on each count on the new one, $50 total, essentially nominal bail, so that she's getting credit on that as well. So $50 imposed there. Ms. McDowell, I'm finding you eligible for counsel. We will get you an attorney on board. We're going to set court dates to June 3rd at 8:30 in the morning. That is 2 weeks from today. Conditions of release on the new driving charges: simply appear timely for any scheduled court hearings, have no new criminal law violations, and do not drive without a valid license and proof of insurance. As for the assault for domestic violence case, that's being maintained at $250. That is what the warrant went out at in 2022. I'm not making it higher, but I'm simply maintaining it. I think after 2 years, that is appropriate. You would have to report to Whatcom County District Court Probation upon any release from custody, check in with them, maintain all of the previously ordered pretrial conditions. So that does include testing, urinalysis, all of that sort of stuff.
Yeah.
So
I have a question.
Yeah, go ahead, ma'am.
Can I ask you a question?
Absolutely.
Initially, when I first got the charge, I was working in a bar, and Mr. McKee advised me that it would be a bad idea to get on an ankle monitor because if I got alcohol on my skin or spilled on the ankle monitor, then it would be a problem. I'm wondering if now that I'm not working and I'm not in bars, if there's a possibility of switching to an ankle monitor method of handling that charge instead of dealing with probation, because I don't have childcare to get to probation appointments easily in the future.
Well, it's not a bad question, but the way it works is the ankle monitor is actually monitored by probation. So unfortunately, there's really no way around that. They would still be monitoring it, and you'd still be required to report to them.
And that would be fine. Okay, but is it... My problem is that dealing with treatment classes that are court appointed as well as dealing with probation, that's double time with no childcare. And I can't take the kids to treatment meetings. If I have a monitor, I can handle being at home with the kids and not, being around alcohol. That's not a problem. What's the problem is being able to meet every single appointment with no foreseeable childcare and no money to get cab fare or bus fare or, and it's money both ways, to and from the courthouse, to and from a treatment facility. Yeah. And I am looking into treatment on the bus route as well.
If there is possibility of the court making a ruling on, if EHM in lieu of bail based on that child care request?
I can't today. I understand defense requests, but this has been in warrant status for 2 years. I feel like 250 is perhaps even low, but I think it's reasonable given what we have, so I'm not going to order EHM in lieu of the bail today. So defense request there is denied. I'm going to maintain the $250. We need to set a couple of hearings. So I already set the pretrial 6-3 on the new case. I need to go back. Was it July 15th is the new out of custody? Okay, so we'll do that July 15th. Presumably, counsel, we just want to track the A4, the old case, to the same dates. Is that okay?
Yes, sir.
Oh, although the new one's DV, so July 11th. Okay, we'll do it all to July 11th out of custody then, and June 3rd in custody. And then, Ms. Souza, as far as the out of custody review, are you fine just setting that to July 11th for the 2 violations alleged, or would you like to hear that earlier?
That would be fine, Your Honor. I think
Just
the
do it.
bail has already been set.
Okay.
So,
All right. So I'll be just 1 minute finishing up these orders here. All right. Signing off on the A4 order. I'm just adding that out of custody date 7/11 on the other one, and I think that takes care of it all. So, Ms. McDowell, I think that does cover everything. If you don't have any further questions at this point, you are good to go. Thank you very much, ma'am.
So what is, my bail is set at
So it's
300
It's $300 total.
in total?
In total.
Okay. That's-
Yep.
Thank you very much.
Thank you.
Your Honor, just a quick clarifying question. What is the out of custody date? I'm not seeing that anywhere in the document.
I'm on the pretrial one. I'm just adding it right now. It's 7/11.
Okay.
At 1:30. I'm just going to track the driving charges to the DV calendar so that they're all together.
Thank you, Your Honor.
Yep. Okay, there we go.
So I just have to say this. She needs to get out of that relationship. It sounds like she's looking at him more like an investment, because she was saying how, you know, she had spent all this time and money to get him clean, and thank God he is clean, but he's not helping. So if he's not helping support you and helping take care of the kids, he wasn't an investment. Relationships aren't investments. You don't put into someone just to get something out from them. I know I've been there, but at some point you cut the rope. You let him go. And, you know, by the way, look what Ava did to me. Yeah. That sweet little angel. Yeah, she did that. She reared up like a horsey and slapped me right across the face. So, yeah, I was gonna say I was gonna say that. I Googled it too, and it says the daily cost is between $5 and $40. So it must depend on what company you go with. Washington will provide them free of charge if they're of a condition of pretrial release. That's when the state or county or whatever takes over the cost. But the monitor itself, if you damage it, if you break it, if you try to take it off and you end up, you know, actually breaking the monitor, you owe the court $1,740. Yep. Thank you, Chinny. Yeah, it's not cheaper than going and testing at the probation office. I know that's what she was trying to avoid, was having to physically go there and pay for the testing, and also all the meetings with the probation officer, because she doesn't have childcare, doesn't have gas money, it doesn't, you know, sounds like she's in a really tough spot. Yeah, exactly. People aren't fixer-uppers. Nope. I 100% get wanting your partner to be clean and hoping that when they get clean, they'll be a better partner. It doesn't always work that way. Yeah, you have to pay the daily fee. There's absolutely a daily fee for those. Yeah, I saw one guy who broke it off of his leg and threw it into a field and then absconded, and they caught him right after they found the ankle monitor, and he had to pay for it. It was damaged in the process of him breaking it off of his leg. Oh, it's not a job that I would want. No, I wouldn't want to do that job. Bless her. Oh, man. All right, Patrick B., I saved it for you. I found a Sav Sit. He's not a good one. How many Sav Sits do you know that convict themselves before the hearing's over?
This appears to be Mr. Heidman, not Mr. Forrest. Your 1010 didn't show up.
Okay.
I mean, he's still got some time, but
right.
This is your other.
Okay.
All right, Hunter, what's your last name?
Heidman.
All right, I do need you to take your hat off, though. We are in court.
Yes, sir. Sorry about that.
That's all right. All right, gentlemen, this is a citation that was issued on April 25th of this year on I-196 there in Ganges Township. It's a citation, 2 citations, careless driving and no proof of insurance. I no longer have no proof of insurance, so you must have taken care of that. We're only here on the moving violation. On this moving violation, Mr. Heidman, you need to do one of 3 things. First is you could admit responsibility to the citation, or 2, admit responsibility, but you'd like to provide some sort of explanation as to how or why that happened. Or 3, you wish to contest the citation, in other words, fight the ticket at what we call informal hearing. What were you looking to do?
I was looking to fight the ticket.
All right. Now the first thing I'm going to do is swear you both in.
Informal hearing.
You raise your right hand. Mr. Heidman, raise your right hand. Swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Yes.
All right. Mr. Heidman, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why you were issued a citation in the first place. But after that, you'll have an opportunity to either ask questions or testify in your own behalf. All right?
If that's how it works, okay.
Deputy, you want to pick up the narrative somewhere where it makes sense? Explain the issuing of this citation.
Yes, sir. So on April 25th, 2024, I was patrolling the area of Ganges Township and Casco Township. I was notified by another deputy on 1916 hours that he was unable to flip around on a vehicle that was speeding on the highway. The deputy advised me that the vehicle was traveling northbound from mile marker 22 at a high rate of speed. At this time, I then was able to position my vehicle on northbound 130, or check that, I'm sorry, on I-196 near the 3-1 mile marker and observed the vehicle identified as a 2014 Chevy pickup truck, silver in color, traveling in the left-hand lane. I then activated my moving front radar and observed reading of 98 miles per hour steady in the left-hand lane on the 2014 silver Chevy pickup truck. The vehicle was cutting in between other vehicles as it was attempting to pass them, passing vehicles on the right as well as cutting into the left lane, tailgating other vehicles, trying to get around them. I continued to follow the vehicle as it continued to travel at 98 miles per hour and it posted in 70 mile per hour zone near the mile marker of the 31 in Ganges Township. I then was able to conduct a traffic stop in a marked patrol vehicle with overhead lights activated on the 2014 Chevy pickup truck. The vehicle did yield to my emergency lights on northbound I-196 and made contact with the driver. The driver advised that he was traveling back to his residence in Grant. He advised that he did not have any insurance during the time of the stop, and I also indicated the reason for the stop. The driver stated that he was just trying to get back home. I provided him with citation number SD 28066 for the careless driving as well as the no proof of insurance.
All right, Mr. Heidman, what is it you'd like to tell me?
So all I am wondering is he says I was traveling at 98 miles an hour, except at the scene of the whole, when it all came to fruition, I asked him how fast I was traveling because I wasn't really nowhere. Yes, I passed a couple cars that were traveling in the left lane. I did pass him on the right. I'll admit to that. But he couldn't give me a speed on how fast I was traveling and speeding, but I'm telling you, I wasn't going 98 miles an hour. So that's why I wanted to fight this ticket. My truck doesn't go 98 miles an hour. I could bring it to you guys and you can test it, whatever. My truck don't go 98 miles an hour.
All right.
So
well,
that's all why I wanted to fight the thing down.
We'll go back
He couldn't
to
give
the
me a
deputy
speed
and
on
have
how
him,
fast I was going.
Have him articulate how he acquired that number. Deputy Early, you want to put a little more meat on the bone about how you came up with that number?
Yep. So originally I witnessed the vehicle. Again, it was that 2014 Chevy pickup truck. It was actually towing a trailer in the left-hand lane. I observed the vehicle passing other vehicles. At the time, I then activated my front moving radar and observed readings of 98 miles.
All
Multiple.
Right. And
oh, good.
So that was on your front moving radar. Let me just cycle you through some questions. Did it tone out as well?
Yes, sir.
Did that tone match the number you were seeing?
Yes, sir.
Had you tested that radar at beginning and end of your shift?
Yes, sir.
This is the same thing I go through every time. Every single time.
Your separately calibrated speedometer?
Yes, sir.
I have the right to travel.
Did you have
and I
any
have the
issues
right.
with it at the beginning or after the shift? Mr. Heidman, I'm asking questions. You're being quiet now. That's how this works. Deputy, I'm sorry.
Yep.
Beginning and after your shift, were there any issues with the radar?
No, sir.
All right. And are you certified to operate that radar?
Yes, sir.
All right. So I will tell you this, Mr. Heidman, just so you sort of understand how it got to careless. He could have wrote you a speeding citation for 28 over, which is as many points as you'd get for careless anyway. But then he did not write you separate citations for either improper lane use, following too closely. You were doing all this with a trailer and no insurance?
Yeah, I'm a professional driver. I have the right to travel. Speeding, and that is
you're lucky you didn't get a reckless driving, sir. This was enough factors here that you could have got a criminal case instead of just
I'm sorry, Your Honor. I apologize, but this is the same thing I go through every time I've ever dealt with a ticket. Is you got a list you got to read off, and the deputy gets to say his part, and I am guilty until proven innocent by my part. So this country isn't ran the way it used to be. I'll just take my ticket and we can go on from here. I don't want to waste your time.
Then you do need to make arrangements to pay that fines and costs with the district court. But other than that, we are all set. You can go ahead and go.
Thank you. Have a good day.
Deputy, you're the no insurance on Forest is going to be a default. They didn't show up. So you're all set.
Sounds good, sir. I appreciate it.
Thank you.
Yep. You have a good week.
Yeah, apparently he is a professional. And I have a feeling that the reason he didn't go through his SovSit script was because, like he said, that he's done this before. And this is how it always goes. When he busted out, I have a right to travel. I'm like, oh, dude. And then to put his hat on in defiance. Oh, I could not believe he did that. Yeah. He very much failed. He caused his own failure. Oh my gosh. Like, yeah, professional what? Oh man, I'm a professional dog mom. I don't get a trophy. Yeah, professional couch potato. Yeah. Yeah, we got this down pat. We're all professionals. Yeah, when he put his hat on, oh man, I don't even have a hat. other than this. This is my hat. This is my hat. Oh, I couldn't believe that. I was like, oh, Patrick B's gonna love this. Yeah. No, not if he fails that hard. Like, he didn't even get to the script. But like I said, I'm sure that's because, like he said, he's done this before. And he's probably failed just as hard on those times too. We're good at it. Hi, Kiki Blue, and thank you. It's the only hat that I have. Well, unless I want to go out onto the porch and get the Chicago Bears gear. But that was all Papa's before he passed away. I just inherited it. Don't attack me, Packer people. Or Seahawks fans. Oh my gosh. Jenny, I'm so happy you made it. Oh, yeah, the only other one that I have, it's not even really that interesting. It's just, I don't know. I guess they're all that interesting, really. Oh, thank you. Another one from my best friend. Apparently it was on back order when they ordered it for me. So they ordered me one to get sooner because they really wanted me to have it at that time. And this one just got left in the queue and it showed up now. I love it. It's so pretty. It's got the appliques. Oh, I just love it. Thank you so much. In that case, can I come over to your house and nap? Nanas are good places to take naps. The Bears. Yeah, I have a Chicago Bears birdhouse out on my tree outside. And then yeah, there's a coat hanger, I think. It's made out of horseshoes in the Bears colors. And then there's like tons of hats. Yeah. I had a whole bunch of stuff. Hi, Jody Gardner. Hi, Papa Les. I have not even heard of that one, Lucy. You always get into some really nifty stuff, but I've never heard of it. And I can't do the really long stuff. I just can't. I can't. Like, I see the Chad Daybell trial is on, like, what, day 18 or something like that. And I'm just like, nope. Nope. Oh, and there's the chat gonna go. Everybody else has seen it but me. Y'all have fun with that. I'm gonna put another one on. Oh, and that right there, that is why I just can't do it. I have a hard enough time watching, horrible dads in 12 minutes. I can't do days of horrible humans. It just would drain my soul. I haven't seen a lick of it. It just keeps popping up in my feed because YouTube thinks I want to see it, and I don't. But it's there. You guys are gonna have to let me know how it turns out, though. Now I'll have to read on it at least. I can read the cliff notes, but I can't watch stuff like that. Especially not when they get into describing things, I just can't do it. It hurts me. Let's see here.
You're here on a couple of matters. Morning, you're here on an unfiled case. You were arrested on a probable cause affidavit. This affidavit looks like you could be charged with domestic battery and criminal damage to property. I'm here to set your bond on that matter. And in your other matter, you have an arrest detained from community corrections on case number 2021 CR 330, 21 CR 353, 22 CR 91. Those are all alleging that you violated terms of your supervised probation with community corrections, and they placed a hold on you in that matter. Ms. Mackenzie McCoy was your attorney in that matter. If you wish to have appointed counsel, fill out the paperwork, felony paperwork, and we will get Mackenzie McCoy back on that matter, and she can get this set for a motion to revoke probation. Mr. Rutherford, not that bond will make much difference in his other matter, but what's your recommendation for bond?
Well, Your Honor, you're exactly right. The state would be fine with no R bond in this case, given that he has several pending motions to revoke that will be filed.
Okay. In this newest matter, you're going to be released on an OR bond, although you're not going to be able to go anywhere due to your hold from community corrections in the Ellis County Jail until you and your attorney and the county attorney can have a revocation hearing. Okay?
Yes, sir.
Any questions?
No, sir.
All right, thank you.
House. Let's see. Hello.
Hunter House?
Yes, Hunter House.
Mr. House, you're here this morning on a case. You were arrested on distribution of hallucinogenic drugs, to wit, psilocybin mushrooms, more than 100 grams, less than 1 kilogram. No drug tax stamp, possession of marijuana, possession of drug paraphernalia. We're here today to set your bond. Mr. Rutherford.
Your Honor, I believe this would be a level 2 drug felony. Also note that Mr. House has another report alleging distribution of marijuana from earlier this year. With that, the state would request a $25,000 bond, cash commercial surety.
His other matter hasn't been filed, Mr. Rutherford, is that what you're saying?
It has not, Your Honor, and I'm not sure he was ever arrested on it.
Okay. Mr. House, you've heard the request for bond today. Anything you would like to say about the amount of bond requested by the county attorney?
I would just like to say, if you guys let me out on bond, I have my whole family, my mother, father, 3 sisters, my daughter here in town, so I will not run. I'm also in the middle of another case trying to become a legal father for my daughter.
Okay. Well, you assured me you'll show back up in court, but distributing drugs is a community safety that I have to take under consideration, and distributing drugs is not something that I think is safe for our community, and it's certainly not safe around young children. So your bond is set at $25,000 that can be posted by cash or commercial surety. If you're able to bond out, no violation of any laws of any jurisdiction you reside. Maintain contact with your attorney. Keep a current address with the Ellis County Attorney's Office. Make all court dates as scheduled. No possession or consumption of alcohol or illicit drugs while out on bond. You're subject to random blood, breath, and urinalysis testing. That can be done any time of the day or night by any law enforcement officer, any court service officer, any corrections officer, Anytime you come back to this court to see me, you're going to have a urinalysis test. Any illicit substance in your system, you will be remanded to the custody of the Ellis Care.
Yes, sir.
If you're out on bond, July 30th, 2024 at 8:30 a.m. is your next hearing. If you're still in custody, the county attorney's office has until June 4th, 2024 to file formal charges. Any question?
No, sir.
All right, thank you.
Thank you.
Anything else, folks?
No, Your Honor.
Yeah, that was a lot of mushroom soup. Oh my gosh, it's getting redder. She got me good. That darn Ava. She did. She smacked me real good right in the face. And then she unleashed a silent but deadly fart bomb under my desk. She's trying to kill me. I know it. I know it. They do very, very good. They do very well. Take an antihistamine. For this is from her claw. She socked me right in the face. I know. Yeah, I blame Joey because it's the egg in the bacon, egg, and cheese treats. Actually, it's just Ava because that's what Ava does. I know. It hasn't been long since it got trimmed either. I know. Yeah, that's Ava. That's Ava. Really? I never knew that. I take a loratadine every morning. I have to because otherwise I can't breathe. And yeah, but it honestly, by nightfall, the loratadine ain't doing nothing. It's just done. Every once in a while, I have to take a Benadryl on top of it. Oh, look at there. Hi, Sierra made one. I know, right? All the cool things we learn in my chat. I've got the best chat ever. Best chat on YouTube. It's a hashtag now. I know. Well, for all the times that I get schmucked up with my pets. I might have to invest in Benadryl. Only if I take 2. If I take 2 Benadryl, you won't see me the rest of the night. You may not see me for half the next day. I get into this like Benadryl-induced fog the next day. If I take 1, I'm fine. It's weird like that. Every 6 months. I knew there was some point where they stopped being effective. I didn't know that there was an actual like specific time frame for it, but I am glad to know that. No, I know. They're so rude. Ava doesn't care. She's a star. Well, now that you mention it, I had to get the cat food today, and I had to switch from those little Shiba containers. I I had to switch to these metal ones because Ava figured out that foil on top of the Shiba ones can easily be pierced by her teeth. And I woke up to shredded cat food container lids on the floor and empty cat food containers. Yeah, I was not happy. Mm-mm. Oh yeah, for sure. Ooh, I didn't know that. So I should not lock it in the trunk of my car during the summer. It's a bad place for it. I will have to remember that because I'm terrible about that. I will accidentally leave it in my car. Yes, that is a fact. Billy loves anything food. Ava does too. Ava will eat anything. Oh my gosh. Yeah, just a wee bit. There wasn't a lick of an innuendo in that statement, was there? Oh. Only for the kitty cats. Oh my gosh, you guys are awful and amazing at the same time. Excuse me, that one snuck up on me. Oh, the jokes I could make, but I won't. Taco Thursday? It just doesn't have the same ring to it. I mean, they can have it. I mean, what else we got going on Thursday for real? Yeah. It had nothing to do with the fact that they're both pink. Oh, guys, Ava's killing me here. I got to take her back out. And then I think I need to go to bed. Oh my gosh. And I haven't even taken the Benadryl yet. I swear. It's apparently what I get on Tuesdays. She is. And oh my gosh, it's getting worse. Out. Don't be so proud of yourself. Yes, I do still love you, but you stink. Oh, Melanie Copeland, I hope that goes well for you. You need to message me. All right, guys. I love you all. Thank you so much for coming and hanging out with me. I know you've got to go potty. Everybody knows. Be safe, be well, sleep sweet, and much love.